Here is the strangest sentence in American criminal procedure, and it is true. To use your right to remain silent, you have to speak, not think it, not simply stop talking. Say it out loud, clearly enough that a court will later agree you said it, because if you just go quiet, if you do the thing the right is named after, a prosecutor may be allowed to tell a jury about your silence, and the Supreme Court has said that is your fault for not invoking properly. That is the Fifth Amendment as it actually operates. Everyone in America can recite the warnings. Almost nobody knows the conditions attached to them. So today we are doing the Fifth. And unlike most treatments, we are going to start where the public actually lives, with the right to remain silent, and only then work out to the rest of the clause. Because this amendment is not one guarantee. It is 5, stacked in a single sentence, and every one of them has a hole in it. This is Do It for the Case Law. Doctrine Deep Dives, Season 0. The amendments, one at a time, one sharpest gap each. Today the Fifth. Start with what the text grants, because the Fifth is the most crowded sentence in the Bill of Rights. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. That is the grand jury guarantee. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, double jeopardy. Nor shall be compelled in any criminal case to be a witness against himself, self-incrimination. Nor be deprived of life, liberty, or property, without due process of law due process. Nor shall private property be taken for public use without just compensation. The Takings Clause. 5 guarantees, 1 sentence. They cover the entire arc of an encounter with the state, how a prosecution starts, how many times it can happen, what they can make you say, what procedure you are owed, and what they must pay you if they take what is yours. We will get to all 5, but the one that matters most in daily life is the third, so we start there. The self-incrimination clause says you cannot be compelled to be a witness against yourself. For most of American history that meant something narrow. It protected you in the courtroom, on the witness stand. What it did not obviously do was follow you into the back of a police car. In 1966, the court changed that in Miranda versus Arizona, and it did something unusual. Rather than announce a standard and let courts work it out, it wrote the script, quote, "He must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires." End quote. That is where the words on every television show come from. And notice the structure of the rule. It attaches to custodial interrogation. You are in custody. They are questioning you, so the warnings are owed. Both halves of that trigger do work, and both are narrower than people assume. Custody does not mean any encounter with police. It means a restraint on your freedom of movement of the degree associated with a formal arrest, a roadside conversation, a knock at your door, a voluntary trip to the station where you are told you may leave. Courts have found each of those to fall outside custody depending on the circumstances. An interrogation means questioning, or its functional equivalent, that police should know is reasonably likely to produce an incriminating response, which means a spontaneous statement you volunteer, unprompted, is not the product of interrogation at all. Nobody has to warn you before you incriminate yourself on your own initiative. Put those together and you get a rule with a substantial perimeter outside it. There is a great deal of talking to police that Miranda simply does not govern, and the person doing the talking usually cannot tell which side of the line they are standing on. Now here is where the public understanding and the doctrine come apart, and it happens in 2 directions. The first problem is invocation. Suppose you are questioned and you simply say nothing. You have not confessed. You have not waived anything. You have exercised in the plainest possible way the right to remain silent. Have you invoked it? In 2013 in Salinas versus Texas, the court said no. Salinas answered police questions voluntarily before any arrest, and then went quiet when asked a question that would have implicated him. And at trial, the prosecution used that silence against him. The plurality's answer is stark. Quote, "A witness does not expressly invoke the privilege by standing mute." End quote. And the disposition, quote, "Before petitioner could rely on the privilege against self-incrimination, he was required to invoke it. Because he failed to do so, the judgment of the Texas Court of Criminal Appeals is affirmed." End quote. Read that again, because it is the paradox in its purest form. To rely on the privilege against self-incrimination, you were required to invoke it. Silence is not invocation. You must say the words. 3 years earlier, the court had drawn the same line inside the interrogation room. In 2010, in Berghuis versus Thompkins, a suspect sat through nearly 3 hours of questioning, saying almost nothing, and then answered one question, and that answer convicted him. The argument was that his long silence had invoked the right. The court disagreed. Quote, "There is good reason to require an accused who wants to invoke his or her right to remain silent to do so unambiguously." End quote. And it explained exactly what would have worked. Quote, "Thompkins did not say that he wanted to remain silent or that he did not want to talk with the police. Had he made either of these simple, unambiguous statements, he would have invoked his right to cut off questioning. Here he did neither, so he did not invoke his right to remain silent." End quote. So the operating rule is this: remaining silent does not invoke the right to remain silent. Saying I am invoking my right to remain silent invokes the right to remain silent. The distinction sounds like a lawyer's joke. It decides cases. Now the second direction, because the picture is not one-sided, and this show does not oversell. Once you are at trial, the protection is real and it is strong. In 1965, in Griffin versus California, the question was whether a prosecutor could comment to the jury on a defendant's refusal to testify. The court said no. Quote, "We hold that the Fifth Amendment, in its direct application to the federal government, and in its bearing on the states by reason of the 14th Amendment, forbids either comment by the prosecution on the accused's silence or instructions by the court that such silence is evidence of guilt." End quote. And the reasoning is the part worth carrying with you, because it is the principle the invocation cases sit uneasily beside. Quote, "It is a penalty imposed by courts for exercising a constitutional privilege. It cuts down on the privilege by making its assertion costly." End quote. Making its assertion costly. Hold that sentence next to Salinas, where a man's silence before arrest was used as evidence against him, and you can feel the tension in the doctrine. At trial, penalizing silence cuts down the privilege. Before arrest, silence that is not formally invoked is fair game. There is a third piece, and it concerns what happens when the police simply do not follow Miranda at all. Suppose an officer questions you in custody and never warns you. Your statement gets used. You are prosecuted, and let us say you are acquitted. Can you sue the officer for violating your constitutional rights? In 2022, in Vega versus Teco, the court said no, and the reasoning goes to what Miranda actually is. Quote, "Miranda itself and our subsequent cases make clear that Miranda imposed a set of prophylactic rules. Those rules, to be sure, are constitutionally based, but they are prophylactic rules nonetheless." End quote. Prophylactic, meaning protective machinery built by the court to safeguard the underlying right, but not identical to the right itself. And that distinction carries the result, quote, "Because a violation of Miranda is not itself a violation of the Fifth Amendment, and because we see no justification for expanding Miranda to confer a right to sue under Section 1983, the judgment of the Court of Appeals is reversed." End quote. So the most famous protection in American law, the warnings everybody can recite, is a set of judge-made safeguards. Violating them means your statement can be kept out of your trial. It does not mean you can sue. That is the self-incrimination picture. A powerful right, with a formal invocation requirement most people do not know about, and a remedy that lives in the exclusion of evidence rather than in your ability to hold anyone accountable. So the warnings can be skipped, and the statement gets excluded. That sounds like a working remedy until you ask the obvious follow-up question, the one anybody who has actually been through it asks. Suppose the police question you, without the warnings. Suppose they get a statement. Suppose it is thrown out, and you are acquitted, or never charged at all. Can you sue them? You would think so. This is the Bill of Rights. Our whole system for enforcing constitutional rights against state officials runs through one statute, passed after the Civil War, now Section 1983 of Title 42 of the United States Code. It gives you a cause of action against anyone acting under color of state law who deprives you of, in the statute's words, any rights, privileges, or immunities secured by the Constitution and laws. Violate someone's constitutional rights and you can be sued for damages. That is the mechanism. In 2022, in Vega versus Teco, the court held it does not reach a Miranda violation. Terrence Teco was a hospital nursing assistant accused of assaulting a patient. A sheriff's deputy questioned him at work without warnings and obtained a written statement. The statement came in at his trial. He was acquitted anyway, and then he sued the deputy under Section 1983 for taking a statement from him without the warnings the Constitution supposedly required. Here is the holding as the court's own syllabus states it, verbatim. A violation of the Miranda rules does not provide a basis for a Section 1983 claim. Now the reasoning is where the interesting part lives, and it is worth following carefully, because it is doing something subtle to a right you thought you had. Section 1983 only covers the deprivation of rights secured by the Constitution. So the question became, is a Miranda violation a constitutional violation? And the court said no. Miranda, it explained, did not announce what the Fifth Amendment itself requires. Miranda announced a set of prophylactic rules, protective machinery the court built around the Fifth Amendment right, to make that right easier to safeguard in the pressured environment of custodial interrogation. Constitutionally based, yes, but not themselves the Constitution. Here is that step verbatim. In sum, a violation of Miranda does not necessarily constitute a violation of the Constitution, and therefore such a violation does not constitute the deprivation of a right postensibel restrict for the calls humanismos pains only are the appeals to this, secured by the Constitution for purposes of Section 1983, and the closing line of the opinion, verbatim. Because a violation of Miranda is not itself a violation of the Fifth Amendment, and because we see no justification for expanding Miranda to confer a right to sue under Section 1983, the judgment of the Court of Appeals is reversed. Sit with the structure of that. The warnings are required. If the police skip them, the statement is inadmissible in the prosecution's case in chief. That much survives. But the requirement is not. In the court's accounting, the Fifth Amendment itself, it is scaffolding around it, and you cannot sue over scaffolding. So work out what that leaves in the hands of the person it is supposed to protect. If the police question you without warnings, and the case against you collapses or is never brought, which is far more common, then nothing has happened, legally speaking. There was no trial, so there was no statement to exclude. The only sanction the doctrine provides is one that operates inside a prosecution that never occurred. The right had exactly one remedy, and that remedy is unavailable to everyone the state does not end up trying. And notice this is the same shape we keep finding, in amendment after amendment, in this season. The Eighth Amendment says the state may not punish you cruelly, then sets a standard for prison conditions so demanding that most suffering never clears it. The Sixth guarantees counsel, then measures counsel by a test almost nothing fails. Here the Fifth guarantees you will not be compelled to be a witness against yourself, and the court builds famous, memorized, universally recognized warnings to protect it, and then holds that those warnings are not the right itself, so breaching them is not a constitutional injury you can be compensated for. The pattern is not that these rights are fake. Teko's statement would have been excluded. That is real. The pattern is that the enforcement is calibrated to the courtroom rather than to the encounter. Everything the doctrine offers you, it offers on the assumption that you will one day be a defendant standing in front of a judge. If you are simply a person to whom the police did something, the guarantee is on the page, and the machinery for doing anything about it is somewhere else. Now to the second guarantee, which is where most treatments of the Fifth Amendment begin, and where this one arrives second on purpose. Double jeopardy. The text says no person shall be subject for the same offense to be twice put in jeopardy. Read plainly. That is one of the cleaner promises in the Constitution. The state gets one attempt to take your liberty for a given crime. If it fails, it does not get another. Watch the counting problems dismantle it. Everything turns on two words, same offense. If the government can turn one act into two different offenses, the word twice never triggers, and the court has supplied two separate ways to do that. The first is about elements, and it comes from a 1932 case, Blockberger v. United States. Quote, where the same act or transaction constitutes a violation of two distinct statutory provisions, the test to be applied to determine whether there are two offenses or only one is whether each provision requires proof of a fact which the other does not. End quote. So a single act, charged under two statutes with slightly different elements, is not one offense tried twice. It is two offenses, each entitled to its own trial. The second is larger. It is the separate sovereigns doctrine, reaffirmed in 2019 in Gamble v. United States, where a man convicted under state law for firearm possession was then prosecuted federally for the same possession. The court's syllogism, quote, an offense is defined by a law, and each law is defined by a sovereign. Thus, where there are two sovereigns, there are two laws and two offenses, end quote. And the court was explicit that it did not regard this as a loophole, quote, the doctrine is not an exception to the double jeopardy right but follows from the Fifth Amendment's text, end quote. Same conduct, same day, same person, two sovereigns, two offenses, two trials, and no violation. It is worth saying what double jeopardy does still do, because the counting rules can make it sound hollow, and it is not. Within a single sovereign, an acquittal is close to absolute. A jury's not guilty verdict cannot be appealed, reviewed, or retried, even if the verdict was plainly wrong, even if new evidence surfaces the next morning. That finality is one of the most unqualified protections in the entire Constitution. The clause also bars a second prosecution after conviction for the same offense, and it bars multiple punishments for that offense in a single proceeding. The doctrine also has to answer a question the text does not address. When does jeopardy actually begin? Because the protection only attaches once you are in jeopardy, and the moment matters enormously. It determines whether the government can walk away from a faltering case and start over. In a jury trial, the answer is when the jury is sworn in a bench trial, when the first witness is sworn. Before that point, a dismissal generally costs the prosecution nothing. After it, the calculus changes completely. There is one more thing to say about the takings clause, and it takes us right back to something we established earlier in this episode, which is why I saved it for last. Remember the statute, Section 1983, the post-Civil War law that lets you sue a state official who deprives you of a constitutional right. We spent time on it because of Vega, where the court held that a Miranda violation is not the kind of deprivation that statute reaches. Now watch the same statute work in the opposite direction, inside the same amendment. For 34 years, a property owner who believed a local government had taken his property without paying for it could not simply go to federal court. A 1985 decision required him to sue in state court first, and a 2005 decision then held that once a state court had ruled, That ruling generally barred him from federal court altogether. Here is how the court described the result. Verbatim. The takings plaintiff thus finds himself in a catch-22. He cannot go to federal court without going to state court first, but if he goes to state court and loses, his claim will be barred in federal court. The federal claim dies aborning. That is the court's own account of a right with no federal door. And in 2019, in Mead v. Township of Scott, it tore the rule out. Here is the reasoning, verbatim. Plaintiffs asserting any other constitutional claim are guaranteed a federal forum under Section 1983, but the state litigation requirement hands authority over federal takings claims to state courts. The court said the rule relegated the takings clause, in its words, to the status of a poor relation among the provisions of the Bill of Rights. And here is the disposition, verbatim. The provision is authentic. A property owner may bring a takings claim under Section 1983 upon the taking of his property without just compensation by a local government. So inside one amendment, one statute, two answers. If the police question you without the warnings, that is not a deprivation you can sue over. If the town takes your land without paying, it is, and the court went out of its way to clear the path. And the takings clause still has teeth, which is worth saying plainly, because this show does not only report erosion. In 2023, the court decided Tyler v. Hennepin County. Geraldine Tyler owed about $15,000 in property taxes. The county seized her condominium, sold it for $40,000, kept every cent, and pointed out that state law let it. The court was unanimous against the county, and the line that decides it is one sentence, verbatim. A taxpayer who loses her $40,000 house to the state to fulfill a $15,000 tax debt has made a far greater contribution to the public fisc than she owed. The taxpayer must render unto Caesar what is Caesar's, but no more. Now set that against what happened outside the courts. After Kalo, the political reaction was enormous. Ilya Summon, writing in the Minnesota Law Review, counted 43 states enacting post-Kalo reform legislation and observed that the backlash probably produced more new state legislation than any other Supreme Court decision in history. And then he asked whether the laws did anything. His conclusion was that most of them are likely to be ineffective, and his explanation was that widespread political ignorance let legislators pass off primarily cosmetic laws as meaningful reform. Two researchers at the Lincoln Institute of Land Policy, coming at it from land use policy rather than constitutional law, found the same thing: reforms largely symbolic, one analyst calling them merely hortatory fluff, and little evidence that condemnations actually fell. They also note a detail that ought to be better known in New London itself. 100 of the 115 properties were sold voluntarily. The case everybody remembers was not typical even of its own facts, so the pattern holds. When the remedy is a specific person owed a specific sum, the clause works, and the court has been busy restoring access to it. When the remedy is supposed to come from the political process, you get 43 statutes and not much else. So the picture is not that double jeopardy fails, it is that its core is granite and its edges are defined by counting rules the text never mentions, which leaves 3 guarantees, and they deserve more than a footnote, because each one cedes a season. The grand jury clause is the strangest of the 5, because it is one of the very few provisions of the Bill of Rights that was never applied to the states. That comes from an 1884 case, Hurtado v. California, where California prosecuted a man by information, a prosecutor's charging document, rather than by grand jury indictment. The court held that due process did not require the grand jury. Quote, "We are unable to say that the substitution for a presentment or indictment by a grand jury of the proceeding by information after examination and commitment by a magistrate is not due process of law." End quote. When the court surveyed the incorporation landscape in 2010, in McDonald v. City of Chicago, it described the grand jury requirement as one of only 4 Bill of Rights protections not fully applied to the states, alongside the Third Amendment, the Seventh Amendment civil jury, and the excessive fines clause, and it noted the practical consequence. As a result of Hurtado, most states do not require grand jury indictment in all felony cases, and many have no grand juries at all. I am giving you that as the court's own description of the landscape as of 2010, not as a claim about where every piece of it stands today. The due process clause is the quiet giant, and it is worth understanding why lawyers talk about it in 2 entirely different registers. Pastoral due process is the intuitive half. Before the government takes your life, your liberty, or your property, it owes you fair process. Notice that it is happening, and a meaningful chance to contest it before a neutral decision maker. How much process is a sliding scale, calibrated to what is at stake and how likely the procedure is to get the answer right. That is the doctrine behind hearings before benefits are cut off, before a license is pulled, before a parolee goes back inside. Substantive due process is the contested half, and the name is almost a contradiction. The idea that the clause protects certain liberties so fundamental that no amount of process justifies taking them. That is the vehicle through which the 14th Amendment's identical language carried most of the Bill of Rights against the states, and the home of rights the Constitution never spells out by name. It is also the most fought-over doctrine in American constitutional law, and where its boundaries sit today is a live question rather than a settled one. Both halves live in those same 5 words: nor be deprived of life, liberty, or property without due process of law. That is not a segment, that is several seasons. And the takings clause is the one that reaches people who never see a courtroom. Private property shall not be taken for public use without just compensation. The fight is over what public use means, and in 2005, in Kelo versus City of New London, the court read it broadly. A city condemned private homes as part of an economic development plan, transferring the land to private developers. The court upheld it, quote, because that plan unquestionably serves a public purpose. The takings challenged here satisfy the public use requirement of the Fifth Amendment, end quote. And the reasoning, quote, promoting economic development is a traditional and long-accepted function of government. There is, moreover, no principled way of distinguishing economic development from the other public purposes that we have recognized, end quote. Public use became public purpose. If you have ever wondered why so many states passed eminent domain reform laws in the years right after 2005, that opinion is the reason. So where does that leave the Fifth Amendment? Here is the thesis, and it holds across all 5 guarantees. Every one of them is real, and every one of them is bounded by a rule about legal structure rather than about your experience of the thing the right is supposed to protect you from. You are protected from compelled self-incrimination, provided you invoke the privilege in the right words at the right time. And if the police ignore the warnings entirely, your remedy is that the statement stays out, not that anyone answers for it. You are protected from double jeopardy, unless the elements differ or the sovereigns differ, in which case you may be tried twice for one act and lose neither claim. You are entitled to a grand jury in federal court. Your property cannot be taken except for public use, and public use means public purpose, which is a great deal broader. Notice what all 4 of those have in common. The protection tracks a structural question. How many statutes, how many sovereigns, which court system, which category of public benefit? What it does not track is the thing the person actually undergoes, being questioned without knowing the magic words, standing trial a second time for the same day of their life, watching their house become someone else's development. That is the gap. Not that the Fifth Amendment is weak, it is not, but that its strength is distributed by legal architecture rather than by lived experience. And the single most useful thing you can take from this episode is the practical corollary. If you are ever in that room, silence is not enough. Say it out loud. That is the primer. A full Fifth Amendment season on this show would take each guarantee in turn. The grand jury and why it stayed behind double jeopardy in its full complexity, including what counts as an acquittal, and when jeopardy attaches the self-incrimination clause and the entire Miranda world, including what survives of it after Vega due process, both procedural and substantive, and the takings clause from Kelo through the state reforms that answered it. 1 doctrinal question per episode, each anchored in cases we verify, not remember. A quick word on how this show works, and then I will let you go. Everything you just heard is legal education, not legal advice. We are teaching how the doctrine moves, not telling you what to do if you are ever the person in that room. And everything is built on real, named, verified cases. Every holding quoted today was pulled from the court's own opinion before a word was written, and you will find every citation in the show notes. That is the whole ethos, and it is the name of the show. Do it for the case law. I will see you at the next amendment.